Thank you, Karen, for joining us today.
Thank you so much for the introduction, Baljinder. Thank you everyone for coming, and especially Sarah and Alessia for putting this presentation and making it possible. And thank you so much for the invitation. So I'm located in Fernie, British Columbia, and I acknowledge my respect for and share my deepest gratitude to the Ktunaxa people on whose homelands I'm honored to live and work. Today, my presentation is going to be on collaborative family law, mediation and arbitration in family law matters. I briefly looked at many of your bios when I saw that you've signed up for the session. I see that many of you are legal advocates, family law advocates. So hopefully this presentation will speak to techniques or preparation methods that you can use in all of your daily practices and in assisting your clients. So I love questions. Baljinder will be monitoring the chat for any questions that you may have. And without further ado, let's head into the presentation. So here's a brief agenda of what we are going to be discussing today. First of all, we're going to talk about an overview of alternate dispute resolution options that exist within our family law process. And then we're going to talk about collaborative family law, when to choose collaborative family law as an option. After that, we're going to talk about mediation, some overview and steps, then arbitration. Then we're going to talk about preparing clients for mediation and arbitration. These two are probably kind of the most useful topics in terms of actual skills that you can take back to your clients and your practice. And finally, we're going to talk about when is mediation and arbitration appropriate. So we have about an hour and a half. We'll go through as much as we can. These are some really big topics. So I welcome all of your questions. And in terms of my own practice, I am a family law lawyer and also a family law mediator. So I've both ran mediations and also been part of other mediation and arbitrations as my role as a family lawyer representing clients. So hopefully I can give you different views in terms of approaching all of these processes from various points of views. So let's talk about alternate dispute resolution options overall. We start off with this because people kind of join the family law systems, and you'll find clients who are halfway through in the process, or they're just separating, or maybe they're contemplating separation. So you find clients in all sorts of pathways already, and you kind of have to take them where you find them. But depending on what their issues are and where they're at, what court systems they might already be in, some of these options will be available to them and applicable to their situation. So I just want to go through them at the very beginning, and then we're going to talk about how all of these skills, mediation, arbitration skill sets, can fit into some of these areas. So first of all, we encounter collaborative separations. And generally, these involve practitioners that might be part of the BC Collaborative Roster Society. We'll get into a little bit of what that means next on the presentation. Then there are these private mediation options and mediation arbitration, which I will shorten and called MedArb. So these are paid for services that you engage a private mediator or a private mediator arbitrator. Then, of course, we have the free public service that is funded by the government, which are the family justice counselors. This is a widely available service across the province, which is, there's no fee to the client. It is part of a mediation process. Then there is a lot of dispute resolution through the court system itself. First of all, we see judicial case conferences as part of Supreme Court matters. This can be Supreme Court family or Supreme Court civil matters. Judicial case conferences are like a mediation, but they are with a judge. And the judge somewhat steps into the role of a mediator and talks to both parties and or their lawyers. Then we have family case conferences and settlement conferences. These are found mostly in provincial courts. Some settlement conferences are in Supreme, but these are similar, where a judge is essentially acting in the role of a neutral mediator and trying to discuss issues with parties. We also see case conferences in child protection matters. These are under the Child, Family, and Community Services Act, and they're called Rule 2 case conferences. They are mandatory under the rules, and this is where the director for the ministry and the parents or any other support people, social workers, they can all participate in a case conference situation that is mediated by a judge. And finally, there is child protection mediation. These are mediated by not a judge mediator, but a private mediator, but they are usually paid for by the ministry, and the director engages the services of a neutral mediator, and community parties, any support people can all participate in these, and they can go much longer than the court ones, which usually go about an hour and a half. These can be full day mediations that are available if requested by one of the parties in a child protection matter. So this is a broad overview of where you might see mediation, arbitration, and collaborative efforts come through in our current system. There are other ones that are, less well known, but these are the core ones that you see mediation being at the forefront. So let's talk a little bit about collaborative family law. This is a process where each spouse hires a lawyer who practices in collaborative family law. Now, one might wonder, where do you find this? You would locate these practitioners in the BC Collaborative Roster Society. And usually what this is lawyers who are family lawyers have trained specifically in collaborative family law, and they understand the process, and they understand the specific context in which they work. And it's usually you hire a private lawyer who practices within the collaborative realm. Your spouse needs to also agree to do this. Now, an agreement is signed at the very beginning between you and your spouse, agreeing that both of you are promising to work together. And the goal is essentially to settle the entire case fairly without going to court. And basically, if the process fails and neither of the parties could agree at the end of the day, then all the lawyers have to withdraw from the case, and none of the lawyers that were the parties started with continues on. So the parties would hire new lawyers if they do end up going to court. So in terms of who can choose collaborative family law, really anybody can if they're going through a separation or have family law needs. The focus here is always on the needs of the parties and the children. The entire process is absolutely not meant to be adversarial. It requires that both parties really wish to make a sincere effort to understand the other side's concerns. There needs to be really prompt disclosure of any relevant information. This could be income information, tax return information, etc. You need to be able to communicate with honesty and with respect. And essentially, the lawyers and the parties all meet together regularly to try to find a settlement that is right for both of the parties. And in engaging a collaborative process, it's not just with the two lawyers and the parties. Typically, there could be a whole host of a team of professionals assisting the parties. They might include divorce coaches, financial specialists, or child specialists. I'll go a little bit into what kind of each of these specialists do. Now, a divorce coach is someone who is there just as like the support person of the people going through a separation. They explore their emotions, they talk about communication skills, they talk about co-parenting strategies, and they build co-parenting plans. And they sometimes each party would have their own coaches, and they really take care of the emotional, intellectual kind of needs of the parties. Then parties might also hire financial specialists who are usually certified financial planners. These people will gather financial information. They can give some financial advice. They can identify tax issues, help parties with budgets, or if they have lots of debts, they might do complex debt repayment plans. Then a team might also include child specialists. They focus very exclusively on the children and the children's needs and some of the children's concerns. They chat with the children in kind of a neutral environment. They create co-parenting plans based on the needs and desires of the children. And they kind of talk to the kids to make sure the children have the tools required to navigate, all the transitions and the separation. Now, in terms of when is it appropriate? Well, first of all, both parties must be willing to work together with honesty and respect. There is a caveat that just simply being high conflict is not necessarily a bar to participating in a collaborative separation. However, both parties must be willing to, of course, engage in this process in good faith. Now, for me, I think collaborative family law it's amazing. Sometimes always in theory, and many times in practice. Personally, I've found that if you live in a rural location like I do, there are definitely accessibility problems with it. To find both parties to find a collaborative family law lawyer and to find all of these professionals. It's very difficult in many rural locations. And even if you can, sometimes each of these professionals, charge hundreds of dollars, per hour. It is very rarely that you would find professionals who would be willing to do this type of work on a, pro bono or a reduced rate basis. So I find that, there's definitely a component where there's going to be a lot of legwork to seek out these professionals and to ascertain that, the fee structures are really feasible for families. And from personal experience, unfortunately, I would say many of my families would not be able to afford, the full team and or just all those professionals, and to have them readily available for our community is very difficult. So overall, though, if it is a successful process, it can be less expensive than traditional litigation. And this is where I compare it to, it might still cost a lot of money, but it is certainly, much less expensive than, running a Supreme Court family trial, for example. However, I say that bearing in mind that this is still going to be out of reach for many families. And even though being high conflict is not a bar to participation, genuinely finding two separating people who are willing to work together with that much honesty and openness, especially at the outset of a separation, is rare. Much more often, I would find about one party would be keen to do the process, but it's a difficult discussion to have, and sometimes that in itself is a challenge where people leave a relationship and they're not ready to either accept with openness or be open themselves. So I think there are certain challenges in the collaborative process. It is, again, amazing in kind of theory, and I think it can be amazing in practice if both parties have both the means and the desire to participate. And that is, I think, the biggest hurdle in terms of collaborative family law. is the accessibility and the means and the desire portion. But maybe as with many things in life. So I will welcome any questions you may have about the collaborative process prior to moving on to mediation. Of course, I welcome your questions throughout. It's just that we'll be moving on to some very different topics. So if you do have one specific question about collaborative family law, you can go ahead and ask those questions now, because then we'll move on to the next topic. And so we don't kind of get lost in our big discussion here. Okay, so moving on, mediation and family law. So let's talk a little bit about what it is. Mediation is a managed process, generally speaking, where two or more parties work together with a neutral third party to try to reach an agreement. That's basically mediation in a nutshell. You can see this kind of manifest in a whole host of ways. The neutral third party could be a judge, could be a trained family law mediator, could be a trained mediator, but not necessarily in family law. It manifests in many different ways, but the general idea is you sit the parties down, you have a neutral person, and the neutral person try to get them to move in their position, talk about their needs and desires, and try to come up with a solution of some kind. So essentially, it's a negotiation process with the assistance of the mediator. It is intended ultimately to resolve disputes without going to court, although parties could already be in court when they start the process. Parties, of course, need to be motivated to work together at least a little bit. You can compel people to go to mediations. And overall, I don't know there are that many people who, have zero desire ever of settling their court matters. I think they might be very different in their positions, but generally speaking, it's not always the case that everybody wants a kind of a scorched earth, litigation that costs a whole bunch of money. At the end of the day, we find that most people generally have at least a little bit of a desire to reach an outcome if we engage in the process. So obviously, though, parties need to be aware that there's going to be some give and take when you get into a mediation. So in terms of why people would choose mediation generally, it's because it's less expensive than a full-on court trial. It is much less acrimonious than litigation. And but what I mean by this is when you go into any kind of a litigation process, be it you take the stand or you commit into writing in an affidavit your client's point of views, it's usually not going to be very friendly to the other side. I mean, you read an affidavit and it's always about how, I'm the better parent, the other side screwed up in doing something. And even even if it wasn't super high conflict, it's always one side saying, I'm the better party in some way, and I did it correctly, and I was wronged in some fashion by the other side. So it really tends to pitch people against each other. And so many people choose this mediation process because they recognize that, hey, I'm a parent, you're a parent, we might be stuck with each other for at least 19 years until our children get older. And we might then still need to see each other at, future weddings or graduations and things like that. So for many people, not burning everything down it's good, because going forward, you still have to try to not be so awkward when you see the other person at all of these big, milestone events. So that's why mediation's great. And in terms of other pros about mediation, it's definitely more expeditious than waiting for court dates and going to court. It allows for rebuilding of relationships, and it does allow for room to rebuild any trust that has been lost. So taking a step back and thinking about, well, who are these mediators? Well, mediators are always trained professionals in British Columbia. Lawyers can also be mediators, such as myself, and we become family law mediators because we've gone through the training and have been accredited by the Law Society of British Columbia. in terms of when people can mediate, well, it's actually available anytime during the process of separating. You can go to a mediation before filing for court, so before any litigation begins. You can step away from court when you're in it and commence it halfway through, so you can do it during litigation. You can pretty much do this anytime prior to having your trial. And in many situations, if the other side is a little bit reluctant, but you want to go for it, these are the Family Law Act sections 61 and into the 200s that you can, compel someone. If you wanted to go to a mediation, you can ask the court to make an order that the other side go with you. So the courts can always compel participation in family dispute resolution. So in terms of what is the outcome of a mediation? Oh, did someone raise their hand? Awesome.
Hi, yeah, I did. I have a question because I have clients come to me often who took part in mediation and created agreement, and then the other side won't sign. And I'm just wondering, how common is that? And is there, what red flags can you watch for that indicate that's a likely outcome?
That's a great question. So I see that a lot too. And I encounter that most often when they've gone to the family justice counselors. That's when it arises quite frequently that the parties have gone to the family justice counselor, and the family justice counselor has worked really hard with the parties to kind of reach an agreement. But then someone right at the end gets cold feet and says, nope, I don't want to sign it. And I think where the problem comes from is because they might not have had legal advice going in. And I'll take a step back and kind of analyze the situation. Many people don't sign, from my experience, because they feel either A, they were rushed into it, 2, they were pressured into it, or they feel, somehow during the process, the pressure has been, placed upon them to agree. And I'm not saying that the mediator pressures everybody to agree to something. That's somewhat their role. It's not undue pressure, but they do encourage people to, come to creative solutions. But that encouragement to some can feel like pressure, and not the good kind. So that's another reason why people don't sign. And the third one, it's due to lack of knowledge. And what it is they've gone into the process, and honestly, maybe they didn't do a lot of research or homework before meeting with the mediator. And there was a lot of maybe lingo and language thrown around in the mediation. Maybe they feel like the other side knows what they're talking about. For many people, if they haven't looked into it at all, and suddenly there are these, someone says, oh yeah, and the child support guidelines says, 2 children, BC resident, you pay $2,360 a month. That could be very shocking to someone who's never looked into it, doesn't know what, the federal child support guidelines even is. And what do you mean that there's a government amount that I got to pay? So I think sometimes, and especially if that discussion then just ends because it's kind of they feel like they've just been told this information and I guess I must go with it. Sometimes that scares people. And unfortunately, once they go home and they're kind of given the document and they're thinking about it, they suddenly just become so uncomfortable with the document because they don't really know what they're signing, and they don't know if they're missing something, or have I screwed up somewhere, and essentially it could be like a case of buyer's remorse. And so to speak to the question about how to avoid that, I would say at the very least, you must encourage clients to look into the literature and look into speaking with duty counsel before going, or getting, a 1-hour consultation session with initial consultation with a family lawyer and, find the money to at least have that 1 hour consultation. Call the law line, from LSS and, speak to someone so that they at least become informed about, okay, when I go to this family justice counselor, these are things that they're going to be talking about. They know, they've done their own guideline calculations. They know what the major issues are. I think if they knew and they entered into the process being confident, being prepared, kind of knowing what their best and worst case scenario is, it becomes much more likely that at the end of the day, they're confident in signing because they come from a place of confidence. Does that answer your question a little bit? I hope, maybe.
Yeah, it does. I also see it with people though who've paid mediators, and maybe it seems oftentimes like it's the party who maybe holds a little bit more of the power that holds out, thinking that they're going to get a better deal if they go to court.
Gotcha. And totally, yeah, it can happen in that situation too. And what I would say is, again, people don't know if they should sign because they don't know if they're signing up for a good deal, a reasonable deal, or a terrible deal. And having that independent legal advice, even before going into a private mediator that you've paid for, also helps. And a lot of times is because the mediator will also warn people. And I know I do as well. So because as a mediator, you're not allowed to give legal advice because you're neutral. You can't say to a party, ooh, I wouldn't do that if I were you. Sometimes if parties are about to do something that maybe they shouldn't do, many mediators will say, especially if they don't have, each party doesn't have the lawyer in the room with them, like their own lawyer, they're not represented by counsel at the mediation. They'll say, look, you might want to get some legal advice on this thing first before you decide to waive spousal support. And many mediators will do that. They'll say specifically, I can't give you any legal advice. You really might want to get some legal advice before agreeing to this. And so, that's why probably a mediation could stall, is because, the parties then really feel like they're not prepared to sign or agree unless they've spoken to counsel. Mm-hmm. Okay, so let's talk about, if you were successful in mediation, typically you would end up getting a consent order or minutes of settlements or a separation agreement. So in terms of who is typically at a mediation, well, you of course have the parties. You can also have the lawyers be there, and also social workers or other important people in their lives. And I've had support people go, I've had family members go, especially in child protection mediations. Frequently, we have had like a big round table of people at a mediation, because you might have, the speech language pathologist who has some contribution to make, or the occupational therapist who has some contribution to make. Or if, the children have been staying with grandparents and they know a lot about what's going on and may be required for the transition, that you invite the grandparents, including the parents, to the meeting. So in terms of the roles of a mediator, the mediator facilitates negotiations. They're there to provide kind of a third-party perspective. They ensure that the settlements are reasonable and they're fair. Again, they cannot provide any legal advice. So that is like very distinct advice as to, oh, you should sign this, or this is a great deal, or you shouldn't sign this. They wouldn't, that's the kind of legal advice that they're not able to give, that's tailored to the parties. Now, the role of providing legal advice will fall on the parties to find a lawyer who can provide that advice. However, having said that, they can discuss generally whether or not a party is being realistic about their expectations. So while one parent can ask the mediator, hey, what is the exact type of child support I should pay? Because that would be legal advice. The mediator could discuss, okay, child support is typically set out with the child support advisory child support guidelines. And if one party says, I don't think I should pay any child support ever, the mediator could discuss whether or not that expectation would be realistic. Now, in terms of how the mediation process works, parties can, and we really suggest that they do, meet with a lawyer that might be able to give them some initial legal advice before starting the mediation. Then the parties can select a mediator jointly, and we do say that parties should do this. I see a question. Can the mediator give their interpretation on a legal issue? Yes, they can. So, David, that is a fantastic question. We do cover that specific topic a little bit later in the slides, but as a brief kind of look into the issues, yes, if both parties ask a mediator about how they think things typically go, the mediator in an evaluative approach can telepath what they expect a court might do. So yes, they can do that. Parties can select the mediator, and they usually will hold a pre-mediation meeting. The pre-mediation meeting is great because this is where the mediator, kind of in a low stress situation, meets with all the parties separately. So the mediator will meet with each person and do a screening for family violence. They'll discuss the expectations of the parties in terms of heading into the mediation process, and they'll try to get to know the parties and get to know the issues that are at play. So the pre-mediation meeting is a great way for the parties to get to feel a little bit more comfortable with the mediator. So in terms of the next steps, the mediator working with the parties and or their lawyers will set the framework. They'll decide on scheduling, so when the mediation is going to happen. They'll set some rules about how materials are exchanged, what the day looks like. They'll set some goals. They'll decide on location and kind of the method that it's run. With the advent of Zoom, we see many of them happen via video conferencing, and they can also decide if it's going to be in person, and even if it's in person, whether or not it's in the same room, or are we doing something called a shuttle mediation? And I'll just briefly explain what a shuttle mediation is. It's also called a closed mediation as opposed to an open one. And this is where not everybody is in the same room. And that could be true even for Zoom. This is where the mediator goes between each sets of parties and talks to them and just carries messages back and forth, but the parties never see each other. So the steps that follow this is an exchange generally of information. So parties will then exchange financial statements. They might have reports, depending on what they have done and what the issues are. Some people might have gotten reports from accountants about tax issues. They might have gotten a professional report on the appraisal of a company. Or counselors might have written reports about the views and needs of the children. Psychologists might have written reports about the kids. There might be reports about someone's income that is known as a guideline income report. Then the next step is for the exchange of something called mediation briefs. So mediation briefs are often prepared by lawyers and or their advocates if they are with lawyers. And the mediation brief is a brief summary of all of the key facts in the case and the party's position and kind of the application of the law in their situation. These briefs can be anywhere from 2 to 10 pages long, generally, and they, if done well, they kind of tell the full story of the file to the mediator, so the mediator can get a good sense of, why we're here and what we're talking about. So in terms of what happens during the mediation itself, we usually start the day by doing welcomes and, introducing everybody. We need to make sure that the mediation agreement is signed. And the parties need to acknowledge that all the discussions that they'll be having that day will be all without prejudice discussions, meaning that if the thing doesn't settle during the mediation, no one can go back and say, well, but you said this and you made this offer. Basically, all of the discussion is closed and off the table. Now, the parties need to make sure that they have paid their mediator, or the mediator is going to talk about the payment plan going forward. They'll confirm the agenda and all of the topics. And then pretty much the parties just take turns giving their thoughts and an overview. And like I said, they can be in the same room or in separate rooms. And I've even done shuttles mediations by Zoom, where there's like a breakout room for each party, and the mediator just kind of, even by Zoom, going through the different rooms in the Zoom as breakout rooms. So as the mediation kind of moves on, the mediator will try to help the parties express and share their concerns. They will discuss the parties' underlying needs and their interests, and try to move the parties away from being too positional about, an example of this would be, say, a parenting issue. Some people are very set on saying, I want to be the primary resident parent, or I want a shared parenting schedule. And they're very stuck on those key words. Those would be positions, but underlying needs might be something totally different. Their needs might be, well, I still want to keep my job. That's, Monday to Friday. And, I want to be able to spend quality time with the children without missing work. So that would be more of an underlying need rather than a stated position like, I want to be the primary resident parent. So then if someone did say, I want a shared parenting schedule, or I want to be the primary resident parent, the mediator will try to reach behind that statement and explore the why. Why is that important to you? What would it look like if, you were having a shared parenting schedule? And then the mediator overall will try to maintain respectful discussions between everyone. And if they're able to settle on certain issues, they will prepare the minutes of settlement describing how the issue is resolved. So this is a good time to kind of, if you have any questions generally about the mediation process, feel free to add them to the chat. I do see a great comment from Vinu, and she says, there's a pro bono collaborative family law project that was being piloted by BC Collaborative Roster Society for Eligible Families. I think it continues, but was having difficulties with uptake, which is a common problem with ADR type options, it seems. I totally agree with that. That is, I actually haven't heard of the pro bono project before from the Collaborative Family Law Project, but that is fantastic if they have kind of started that so that more families could have this as an accessible service and option. The question about difficulties with uptake ultimately might be understanding the collaborative process. It really takes two people who both buy in and understand the process and find themselves to be, open and suitable enough to, run the separation in that fashion. So, if there are no other questions, I'll go through the various topics that are typically covered under a family law mediation. So as you can see, I've listed out all of the kind of major topics here: guardianship, parental responsibilities, parenting time, child support, spousal support, then property division is the final and big one. This is where parties have either lived together for 2 or more years, or they are married. So property division is only for those folks, and it can cover family residence, any other houses they have, land that they have, vehicles, pensions, RSP, bank accounts, debts, any other kind of liabilities, mortgages, loans, These are all in property division. I'm just going to briefly look at the time. We're doing pretty good for time. Okay, so I'll go a little bit into each topic, and these are, of course, I won't be able to go into each of them in depth because, they're a session on its own to discuss them. But if you're working with helping a client with supporting them through mediation, and you're helping them as advocates on their briefs, if you haven't hit all of these topics or ruled them out as things that are not applicable to you, you're certainly missing something. So it's always good to kind of think about this particular slide and to just, maybe guardianship isn't an issue, or maybe spousal support isn't an issue, but at least you need to kind of square that off and understand that, yep, we've covered it, it's just not applicable here. Or property division is not applicable here because they weren't married or didn't live together for more than 2 years. But you must kind of pay attention to each of these topics. Now, guardianship is a decision on who is a guardian. The thing to keep in mind about guardianship is it's very much in the legislation. Certain people are automatically guardians. Certain people are not guardians unless they apply to the court to become one. So that's the important thing about guardianship. Now, parental responsibilities, only guardians can, of course, have parental responsibilities. These are about decision-making, who gets to bring the children to the doctor? Is there sharing of information? Who gets to make decisions, about medical things, about religious upbringing? Those are all questions that fall under parental responsibilities. By and large, these first two topics might not be highly contentious, other than, we always see some hot topic, questions arising right now. The biggest one would be about vaccinations. That would be a question that falls under parental responsibilities. Parenting time is probably the next most highly litigated topic and difficult, I would say, because, of course, it's dealing with people's time with children. Here, again, in a more mediative approach, you are trying to move away from, I need to be a shared parent, or I need to be a primary resident parent, and really just taking everybody's work schedules, taking the children's schedules and looking at a calendar and figuring out, how do we maximize everybody's time with the children? What is most appropriate? What are the children's desires? What works and what doesn't? So that would be, and so that you'd come up with a regular parenting proposal pitch, as well as additional parenting time issues would be like holidays, how do you split up Christmas? How do you share summer holidays, Easter, Thanksgiving, Halloween? These are things that would all fall under parenting time. Next are questions of support, both child and spousal support. Of course, there are two separate sets of government guidelines. We'll talk a little bit about preparing for mediation and arbitration, but generally it would be very important for the parties to be familiar with both guidelines and kind of what they say about their situation. And finally, with property division, this is about gathering lots of information about what each party has in their possession, as well as what they owe to other people or the bank, and coming up with a property division schedule ahead of time. So in terms of tips for a successful mediation, of course, you'd be encouraging clients to express interest in a productive and respectful way. It's important to be open to various ideas which may be raised, and be mindful of whether or not, you're just getting, too worked up, and how your emotions are impacting, your decision-making. Avoid threatening the other person or making personal attacks. For all mediations to work, there must be, full and frank financial disclosure so the parties know what they're signing up for. And to discuss the best and worst case scenarios with the lawyers beforehand is very important. I'll also go into this a little bit later when I cover litigation risks. Now, we encourage parties not to interrupt each other. And you can always let your clients know it's their process. If they need a break halfway through, if things are looking to be very heated, you can always ask for a break from the mediator. And of course, at the end of the day, you're trying to encourage everybody to be as honest and empathetic as they can be in the situation. Now, as a brief overview of arbitration, what is an arbitration? Well, arbitrators, they are pretty much a private judge. A family law arbitrator will make binding decisions to resolve family law issues outside of court in lieu of a traditional trial. And basically, the parties are hiring a private arbitrator to make the decision after hearing from both sides. So the important thing to note is that essentially when you go through a family court, you could, of course, have your traditional trial with a judge if you kind of fail out of all the mediation options. However, a trial is still extremely adversarial, very much so, and it will involve, your client taking the stand, waiting quite a while sometimes for a judge to be available. And I'll give an example just from personal experience. So I'm in Fernie. My closest Supreme Court location is in Cranbrook. Cranbrook happens to be on what is known as an assize system. That means our community does not have a judge that lives here and sits at Supreme Court. And we just have judges that fly in from all over the province and stays here for a week or two, and then they're gone. And so our courts in Supreme isn't open every day. It's open for a few days, a month, sometimes a week, sometimes 2 weeks. And only during those times can you schedule any type of trial. It could be, and the issue is you have criminal files, civil files, family files, all lining up to have hearing dates for small applications or trial dates. And because there's so much demand and very limited time slots every month, it is super competitive and very difficult to be chosen to go to trial at any particular point. So frequently what you see is the unfortunate situation of someone hiring a lawyer, preparing for trial, thinking that, oh, my trial's, scheduled for October, show up in October and be told, hey, we actually won't have time to hear your file. And then, it's really upsetting emotionally, obviously, very upsetting financially because you've paid for your lawyer and prepared for the day. And now your lawyer must then resubmit for a new date and line up all over again. And unfortunately, what happens is you could be in line again and again over the course of many months and never be selected. It's also not the case that if just that you weren't selected last time, you would be selected the following time. It's one of the factors if you've been waiting a long time, but if there was an urgent criminal matter, that will almost always trump any family trial. And so we frequently, and that makes sense to me because there are, if someone's in jail and awaiting trial, their liberty is at stake. So it's not a complaint from that perspective from a kind of a theoretical basis, but it's very difficult for, my family files and their clients to be continually paying for, Karen to prepare for the trial and be ready to go, only to be let down, on the day of. So that's why many people now are turning to these arbitrations. It's because you pay for the service and you book the arbitrator's time. And when you book it, it happens that, the arbitrator doesn't double book you when you're guaranteed to go. So they weigh, yes, I pay for a private arbitrator, but at the end of the day, I'm not paying for Karen to, sit and wait for court 5 times. And, there's definitely a mathematical kind of consideration there in terms of financial and just the stress of, waiting and being let down in an assize system, or even in a regular system where your, trial dates are overall almost always double or triple booked in any registry. So that's why I think arbitrations are, getting more and more popular. Now let's head into a specific description of mediation arbitration, or MEDARB. So MEDARB allows a mediator of an unresolved dispute to assume the role of an arbitrator in relation to all or some particular issues that remain in dispute between the parties. So what happens is, if you start in a MEDARB process, meaning you start with a mediation, then if you mediate, say, in the giant list of topics, guardianship, parenting time, parental responsibilities, child support, spousal support, let's say you go through your mediation and you agree to everything except for spousal support. Then your mediator at the end of that process will go like, okay, it looks like you guys are far, far apart on the spousal support issue. I don't think it's worth anyone's time to spend more time on trying to resolve it because everybody's too far apart. In which case the mediator then puts on the arbitrator hat and then will just decide. So the benefit of that is, of course, it's time and cost effective, especially in an assize system. You're not failing out of a mediation and then waiting for a trial. Like I said, the scheduling is very flexible. The mediator arbitrator will tell you when they're available and then you book in a time. It is private, meaning, the arbitrator, the process is private between the parties and the arbitrator. You're not sitting in open court. The parties, of course, can select their mediator arbitrator. And there's, of course, more buy-in from the parties because they chose the process. They paid for this person jointly and they chose the arbitrator out of hundreds of arbitrators. So, whereas, of course, with a judge, you don't know who's going to show up on your trial date. You can't select your judge. So, you haven't read the judge's bio and it doesn't matter. You get who you get. So with a mediator arbitrator, you can select the person that from a giant roster of people. Now, in terms of how to design a MEDARB, so the MEDARB process can be streamlined and crafted with the assistance of a mediator arbitrator. And again, in a MEDARB, you can have closed or open sessions, so shuttle between rooms or everyone is in the same room. The specifics of it being a MEDARB and an open session, if you're kind of talking our client through which is more appropriate, we see shuttle mediations a lot when there's been some kind of family violence. So just there having been family violence doesn't mean that mediation and arbitration are off limits to you. It just means that the mediator and your lawyers collaboratively will need to find a way so that you account for the family violence which has occurred, and the one party, the complainant, doesn't feel that they're subject to any kind of undue pressure, especially in being in an open session, in the same room as the perpetrator. So, closed sessions and shuttling between rooms is a very common way to adjust for any family violence that has occurred or any kind of power imbalances. And of course, having the one party being supported by either a lawyer or a close family member or an advocate would be why it might be necessary in the circumstances of where family violence has occurred. Open sessions definitely, though, have its own pros as to why you would choose an open session on purpose. So you might choose an open session on purpose because you want to see what the other side's going to say, like in person. There's some magic about being in the same, forced to be in the same virtual or real room where you get people actually talking to each other, looking at each other in the eye and sharing their concerns. It just feels so much more real, and the emotions start to come out. But maybe in a positive way. It's hard to be empathetic about someone if they're not in the room. It's easy to be empathetic and to really see how much distress they are in. And, when they say they're concerned, they do look concerned. So in an open session, you get all of that. You could also ask pointed questions directed to the other person in an open session, like, why would you have come up with that? Or what really happened here? What are you looking for? So I think, and, also in open sessions, especially where there are lawyers supporting each side, I've had mediators ask very pointed questions about problem areas in each party's case. And it doesn't so much put the clients on the spot, it certainly puts the lawyers on the spot, especially if they have some kind of indefensible position that they're advancing. And, the mediator will go like, well, Karen, why would your client take this position? And, I've been grilled just like you get grilled by a judge, perhaps, but by a mediator about, why you think something might be. And it's not malicious. It's just everybody is genuinely trying to figure out why, my client and I have taken a particular position. Why do you think, there should be no spousal support payable? That'd be a very fair question for anybody in an open session to ask. And, if I genuinely think that, based on the case law, there really isn't any spousal support payable, or it should be, on the low end of the scale, well, I better be able to answer that question. And so the other side then can have an opportunity ahead of a trial or an arbitration to really figure out the evidence. So if you have keen ears in a mediation, you can very much use that time to figure out what the other side's case is and where the weaknesses are, or what they're likely going to argue in front of the arbitrator or the judge. So the open sessions, while closed sessions may initially be like a more comfortable setting because there's no affront of seeing the other side, in an open session, there are definitely, lots of useful things that can come out of them. Now, the next point is mediations aren't necessarily single days. In court, a judicial case conference is very regimented. It's an hour and a half, and that's all you get. In a paid-for mediation arbitration, they could be a very long day. They can go for 6 hours a day, 4 hours a day. You can split them up into multiple days. If you don't complete, you can book another day. There's just so much flexibility in the process. Then, of course, during a med-arb in particular, you're going to talk about the exchange of information if the mediation fails. So what that means is, as an example, say one person owns a business, and fine, you've agreed on all things with the exception of how much child support is payable. And say the hang up there might be, well, they own their own business. I mean, they're just paying themselves whatever. And ultimately, what might be needed is an expert report on guideline income of this person who owns the business. Or you might say, actually, I need everyone to do new financial statements because, we haven't seen the latest tax returns. So if you fail out of the original mediation and you're heading into arbitration, the arbitrator will generally go over with you, what the exchange of information is going to be and what the timeline surrounding that would be. So finally, if you are in an arbitration, it's kind of fun in that, well, it's not fun for the parties, but from a lawyer perspective, there are many options. So you can either have a traditional arbitration where you set it up like a mini courtroom. Obviously, you're not in court, but people give evidence and you can be cross-examined and you're essentially taking the stand as you would do in a traditional trial. Or if, there aren't that many credibility issues and your lawyers respectively believe that you can just do it all by affidavits, you can have the full trial just by a summary trial version and just do affidavits. And maybe, parties could be examined on the, cross-examined on the affidavits, and that's it. So there are lots of ways to design your own process and lots of flexibility in a mediation arbitration. So these are kind of the more interesting slides, and we've got half hour to go about preparing clients for mediation and for med-arps. So if you have a client who's contemplating this or who might have signed up for a mediation or a med-arp, first of all, it'd be about you learning about the process and trying to assist the parties in understanding the process of a mediation and an arbitration and the steps to each of them. Now, of course, you need to ensure that, the mediator might have done a good job at screening for family violence, discussing any safety concerns. And it could be very minute things about, parties entering and exiting the building at separate entrances, and or, not seeing each other, if they're in the same location. Again, you talk about the pros and cons of open versus shuttle mediation. Then it's about making sure that the important people are available, and they can be available by phone on the day of the mediation. Recently I've had the one mediator say to each of the parties, look, I know your extended family have been very supportive in your separation, respectively, on each side. You should make sure that, you have your sister or your cousin or your brother, the key people that have been supporting you available by phone that day. So whenever we're on break and you need to talk to someone, you'd be able to call those people and have a chat with them. So other important people that you might want by phone might be an accountant or a counselor. We were in a mediation last week where we had to call up one of the accountants to get some tax advice on the spot because we decided to do something different. And we wanted to know, are they going to have to pay capital gains tax on these dividends that they're going to get? And if so, what rate should we account for? So the accountant was great. The accountant joined the Zoom and, answered our questions. And so having important people available and making sure that your clients have those important people lined up, it's kind of like playing, wants to be a millionaire and having your lifeline on the phone. And this might be if your clients decided for cost reasons that they didn't have their lawyer at the mediation, that they might be able to call their lawyers during the break to get some advice. You'd also want to make sure that your clients have had all of their properties, if they needed property evaluations done, that they're done by the time you head into mediation. And any kind of Section 211 views or needs of the children report. You'd help them prepare any witness statements and mediation briefs, and a property and debt division schedule. Now, these things are really fun if you're into Excel spreadsheets. I have very elaborate ones that talk about, each party, all of the assets are listed on one side and all of the corresponding debts. So I might have on one side of the chart, the family residence, then the mortgage, and maybe the home equity line of credit. And then we would have, the truck and the truck loan and the car loan and, the student loan and any other debts and any RSPs they have. And I would have them all in a big chart. And essentially, before the mediation, I work with my clients to make a plan about, well, do you want to keep the house or don't think you want to keep it? And so for every asset, we kind of go through you keep it, the other side keeps it, or we sell it version. So we then work through the chart, we insert all the numbers, and we are able to calculate at the end of the proposal who owes which person what money. And the more difficult situations where there are exclusions and so forth, we can work out what the exclusions might be. And by exclusions, I mean, if there were assets that predates the relationship, if anyone received a big gift from their family members, or if there was an inheritance, and we try to work those out of the table. So we can create some pretty elaborate property and debt division schedules. And when we head into a mediation, we will empower our clients with that document in electronic form, where throughout the day, as the assets gets talked about, their values get talked about, and maybe going up or down or changing, depending on how the discussion goes, and the you keep, I keep, we sell discussion goes. We want to make sure that there's an editable version in electronic form that the parties can sit at their own computer and play along with and follow along the discussion, so they can always keep an eye on kind of the bottom line.
Karen, there is a question on capital gains on dividends. How did that turn out?
Oh, very interesting. So capital gains is a funny thing that sometimes get missed in discussions. And capital gains, and of course, I can't give any tax advice, but I'm just going to raise how this impacts people. So let's say you have 2 houses, okay? And you have, say house 1 is worth 500 grand. House 2 is also worth 500 grand. Well, the misconception would be person A could take house A, person B could take house B. They each walk away with 500 grand, right? The answer is wrong. No, they don't. So the issue of capital gains is only one property ever for a couple, provided that that was their family residence, only that one would have a capital gains principal residence exemption, meaning that there's no capital gains payable, even if, like, say they purchase the house at 100 grand and it rises to 500 grand. So there's a $400,000 increase in value. Well, if that was a family residence, that would be subject to no capital gains. But if it was a secondary residence, then it would be. So you can see if person A gets to keep the $500,000 house and person B gets to keep the other rental house that's also worth 500 grand, technically person B is getting a much worse deal, because further down the line, they're going to have to pay potentially massive taxes on their property when they sell it in the future. And so really, they're not getting the same deal, because person A gets a tax-free house and person B gets a house that will need taxes paid on. So that would be capital gains on property division in terms of houses. Capital gains on dividends is a cool other topic. This is where, say, person A and person B, when they were married, own a company together. And the company is, say, either you got it valued or maybe it's a holding company, so you know exactly how much it's worth. Say the company is worth $200,000. Now, a simplistic view would be, well, if I need to be bought out of the company by the other side gives me 100 grand. That would be a simplistic view, right? $200,000 company split in half would be 100 each, right? Sort of. And the sort of becomes the capital gains problem. Technically, well, depending on the kind of company, and this is where it gets complicated in a tax advice situation, let's say they have no exemptions. In order to get the money out, the money isn't tax-free money. It's probably pre-tax money, meaning when the person receives their half of the company, they need to pay taxes on that. So if wife or husband or one part of the partnership decides to say, hey, I want my money now, if they took all 100 grand out of the company, they're going to be taxed at the highest tax bracket and will be issued a T5 for the whole amount immediately. And that is the dangerous part. People don't realize that they're going to have to pay taxes on it and be taxed so high due to their artificially increased income tax bracket for that year. So there's a lot of planning around, okay, so I want to get half my money out, but maybe I take it over time, meaning that I don't try to take all 100 grand out at the same time, and I split it over a number of years. Or sometimes we'll just say, okay, how about the person who keeps the company just keep it? And I get, $75,000. So not the full 100, I get $75,000 of, in I don't know, investments or something. So, lots of time in order to avoid paying all of the capital gains on dividends right away, in a mediation, you can come up with really collaborative, more ingenious ways of dividing up your assets. So I hope that answers Gary's question about capital gains on dividends. So next up, back to the slide. We're going to talk about support and guideline calculations. We've touched on this briefly. As the advocate and support worker, you really need to head into the spousal support and child support calculators and calculate the best, mid, and worst case scenarios. So there can be complex best, mid, and worst case scenarios, and I'll briefly go into why. First of all, child support is dependent on a number of factors. You've got various numbers that you can plug into the system. Payors' income and recipients' income and the number of kids. All of these things could be in a state of flux. You might not know if your client's income is going to be up or down, and usually many people have a range of incomes. And so you could potentially do many calculation scenarios. Let's say you have a child that's, you have 3 kids, but one of them is doing their gap year and they are, about to turn age 19. So they might age out. So there's some question about whether or not it's really 2 children or 3 children. And then there's some, disagreement about whether or not they're truly doing a shared parenting schedule or not, meaning maybe one of the people have them more than 60 or 60% of the time, so they lose the shared parenting status. So in order to just run child support calculations, you might have to create best, mid, and worst case scenarios by saying, well, what if my person is imputed the highest level of income and the other side is just get their stated income? What if there are 3 children? What if there are 2 children? What if, the children are in a shared, or maybe 2 are in a shared and 1 is not? So there could be a myriad of guideline printouts that you would have in preparing for this mediation and preparing your client for their best, mid, and worst case scenario. That's just on child support. Then there are the similar concerns about spousal support. What if my person's income is high and the other person's income is imputed low? What if it's reversed? What if everyone got imputed mid? And so those impact the calculations. And then within each calculations, there would be a low support, mid support, and high support scenario. And if you pair that with child support, then it gets really complicated, because you also have to, the child support impacts the spousal support in a calculation. So depending on if, the parenting time is shared, then it'll result in a totally different amount of child support payable and a spousal support payable. So running all of those calculations could be quite time consuming. And sometimes as advocates, it'd be really helpful if there's like a binder of all of these possible calculations heading into a mediation, such as a family case conference. If you were really, really keeners in preparing for mediations, some even prepare all the draft orders and draft separations ahead of going, just to have a mini checklist of, did we cover all the topics? At the very minimum, you would have, those 5 major topics that we talked about, but you might have much more detailed, asks or wish lists that you would bring with you to make sure that, in your mediation, you didn't forget, Hanukkah and what that was happening there, So the draft orders, draft outlines of orders or separation agreements are very helpful in prepping for a mediation. Now, like I said, mediations can still occur if there's high conflict or power imbalances. We just need to modify the process. As support workers, you would also run, cost-benefit analysis with clients, run their best and worst case scenario, try to explore their interests and work with them to look beyond positions, and ahead of time, discuss whether or not there's some kind of emotional or verbal or physical trigger for each party. So, we don't mention certain things, or we're aware that, we tell the mediator in a shuttle situation that, these are more high alert discussion topics. So of course, we're always trying to explore workable solutions and sometimes outside of what a court may order. So when you go to a trial, traditionally, you get very scripted outcomes. And in a family law mediation, you can do a lot of creative trades, like the dividend situation that I talked about. A court might simply request one party pay the other person out, and there would be no option in terms of paying it over time. And you kind of take what you get when you get your final trial decision. But in a mediation, going back to this scenario, we could have talked about a trade. The judge is never going to impose a trade on you where you go like, well, you get to keep this nice car if, we deferred the dividends. You would never get that as an option. But here, both parties can be creative and, they can have some control over their own outcomes. And you basically have to encourage your clients to come with their business hats on if they're talking about financial matters, and just be less, understand their own emotions, but be pragmatic about the outcomes. Also, if your clients were keen on buying the other side out of the family residence, retaining one particular home, or needing to refinance in order to pay out, they must get all of their pre-approvals from the bank and their tax advice ahead of time. Many people don't realize that. They have a blind understanding of, I want to keep the home. Well, that's great, but the home has like a $500,000 mortgage, not counting how much you're going to have to pay out to the other side to equalize. So, do you qualify for up to, $600,000? Do you need a co-signer? Do you need to shop around different banks? These are all questions that they need to answer prior to even, pitching a proposal where they go like, I keep the home. So it all leads back to creating plans with longevity and, that are practical. So I promised that we would be talking about this a little bit, which is asking mediators within mediations to be more evaluative. And what that means is they can offer views and suggestions and weigh in on issues. Now, the lawyers of the parties have to both be comfortable with the mediator doing this, but essentially, you can ask all the great mediators, you can ask them outright to poke holes in the other party's position. And then they will, indiscriminately do it. They will say, well, person A, here's the problem with what you're trying to say. And person B, you're good on these points, but, your major problem is with your exclusion claim. I don't think it's going to fly. I don't think there's any case law that would support that. So mediators can, if both parties request them to, telegraph possible outcomes and the strength of each case to the respective sides. Now, this is great if you're working with a client, and let's say they're a bit unrealistic or somewhat out to lunch on issues, and you're just looking for that third person to basically either read them the riot act or tell them like, this is never going to fly, and they're not listening to you, but you think that, with an additional respected mediator or arbitrator weighing in, they just might listen and be able to move a little bit from their, really entrenched positions. It's great because you can kind of get experienced mediators to offer more creative solutions and to let clients, understand some of the options that are out there that they might not have been aware of. So in terms of helping clients with mediation briefs, be aware that, you don't want to be very adversarial in them because you're not at a trial. The other side's going to read them, and really angering them at this stage that early in the process is probably not a good thing and not helpful to your mediation. So you would want to include all of your clients' goals. You want to talk about how the mediator is going to be paid. You want to talk about litigation risk with your clients so they truly understand the strength of their case, especially the range of quantum of damages. With spousal support, that kind of thing could be, how long are you paying for? Could it be 0 years, or are we talking about indefinite support? And in terms of litigation cost, they need to be aware that even if they were at a real trial, if they won, they're not going to dollar for dollar be repaid back for all of their legal fees. It's usually based on a tariff. They might get some reimbursement at cost if they win at trial. This is another reason why, you want to be really frank with how much is the arbitration going to cost, how much is a trial going to cost, and how much is a mediation going to cost. In terms of specifically preparing clients for arbitration, there are other fun things that that is interesting in an arbitration. So sometimes you can get the arbitrator just to decide based on the evidence, meaning the arbitrator could pick spousal support amounts that are $1, that are $5,000. It's up to the arbitrator based on the evidence to pick the number. But some groups, in order to limit their risk and also to avoid spending a lot of money, will do what is called last best offer. And this is where person A, let's say on spousal support, comes up with a number, and person B comes up with their best offer. So it might be person A says $1,000 and the person B says $2,000. And the arbitrator doesn't just decide. They will select one, and that limits the arbitrator to choosing one of the final offers made by the parties instead of just purely calculating on their own any number. So it really limits, it's quicker. There's less emissions required, less time spent on paying the arbitrator writing a decision, and the arbitrator just goes like, I think option A is more reasonable, and that's what goes. You can also do a different kind. So that was called last best offer baseball arbitration. There's also another fun one called nighttime baseball. And that's where the arbitrator will do their own math. And then once they do their own math and say it came to $1,750, and when both of the offers are revealed, they'll pick the one offer that came closest to it. So the $2,000 one would be the one that wins. I know that we're a bit short on time, so we'll just end by saying that, with mediations overall, you're trying to have the mediator come up with the strengths and weaknesses and create, more creative solutions to help the parties. And even if you're unable to reach settlement, usually it's an effort well spent, because at least you would have narrowed down some of your issues and refined and decide what you were going to do for your next step. So it's never truly a waste of time. It is always confidential and flexible. You can come up with creative remedies, and important relationships could be repaired. And the whole thing is without prejudice. Again, you get to choose your decision maker, create some outcomes that are not strictly based on case law, and you can do trades. And overall, I've seen really successful ones. They're transformative. They might result in apologies. And some of these apologies and just acknowledgements could be key components in terms of rebuilding trust. And finally, during mediations, it's such an open environment that people feel free to air their emotional side and some of their concerns, which might not be, something that would typically come out at a trial, because maybe it's based on hearsay. I've heard that your neighbors say, you're using drugs again. Again, that's a hearsay piece of evidence that, you would never be able to raise a trial because, you didn't actually see it happen. But at a mediation, you could air those concerns that are not necessarily strictly, strongly a legal basis concern. Why are you feeding them so much sugar all the time? Again, this is not something that would likely come out at trial, but at a mediation, you just have that much flexibility to talk about parenting issues. It's again faster. You can build long-term solutions. And also, many people choose mediations because their clients are going to be bad witnesses on the stand. They might have engaged in what I would call alternate business endeavors and practices. They might not make the best witnesses, or it might be a problem putting them on the stand. There might be a lot of risk, and they might want privacy about issues. So that's another reason why you would choose mediation. And finally, in terms of why you would choose MedArb, again, it's a definitive result. You book the arbitrator's time, you're going to get an answer. You're not waiting for a trial date, and you can customize the process overall. So that is exactly 3:30. And thank you so much for participating in kind of our presentation today. Do we have any kind of additional questions? All right. And we do have another helpful comment that says Andrea Glenn has shared about pro bono collaborative family law project in a recent presentation. So that is in the chat if you would like the link to that.
Lots of thank yous coming to your way, Karen.
So I hope you enjoyed the presentation. I know it's long, but we didn't actually run over time, so I'm happy about that. And yeah. If you have any other kind of questions or comments, feel free to find me. I'm at Rocky's Law in Fernie. And yeah, thank you for coming.
Thank you, Karen.